Thank you so much, Laura, and thank you for everybody joining us today. My name is Shauna Fleischbein, and I am the Senior Business Development Manager for the Greater Tampa, Sarasota, Orlando area with Castle. And we thank you for joining us, and we thank Alan and Cindy from Tannenbaum for joining us as well today. As Laura said, you're welcome to submit questions throughout. We will try to get as many answered as possible. We have a lot of people joining us today. So if for some reason we cannot get to your question, we're happy to answer questions afterwards. Feel free to send us an email or reach out to us however you prefer. We will be sending, Laura and I will send out emails before the end of the week that is going to have a link to the video recording in case you had to jump off early or you want to share it with somebody. And we'll have contact information for Cindy and Alan and myself and Laura as well. So we'll be sure to get that out to everybody who registered before the end of the week. So anybody who is not familiar with us, Castle Group is a full service management company. We service both HOAs and condominiums throughout the state of Florida. And so we're happy to help you if you have any needs there. Otherwise, I'm going to hand it off to Alan and Cindy so they can get started today on our presentation.
Good morning, everybody. I'm Alan Tannenbaum, partner in Tannenbaum, Lamole & Hill. I'm here with my partner, Cindy Hill. We are a general counsel and a construction firm working primarily in the community association field. We're headquartered in Osprey, but we have offices also, satellite offices in Fort Myers, in Clearwater, and in Orlando. We're going to be talking about the board business judgment rule, which is an important protection for condominium and homeowner association boards of directors, as long as you comply with the limitations set forth by common law and by statute. But it's an important protection, and we're gonna get into that. What we're going to cover today, we'll be talking about the Lambden rule, which is a court-created rule applying to the board business judgment rule in Florida. We're going to be talking about some extensive statutory provisions, both in 718 and 720, that impact fiduciary obligations of board members. We're going to be talking about maintenance and repair failures, what potential board liability exists there, and some insurance and defect claims, whether that suspends repair obligations. And then we'll have a Q&A at the end. But first, we're going to discuss the Lambden rule, and I'm going to turn this portion of the segment over to Cindy Hill, my partner. The common law is the law that's created by the courts, and it operates in conjunction with what the legislature creates statutorily. But this Lambden rule, and Cindy will get into it, basically defines what the court system in Florida has established as the parameters for operation of the board business judgment rule. Cindy, take it away.
All right. Thank you, Alan. Again, I'm Cindy Hill, and I do general counsel work for community associations, and the business judgment rule is a very important rule for helping the board in knowing that it's going to make solid decisions that are unlikely to be contested successfully in a court. As Alan was saying, this is a rule that has been set up by the courts. You won't find this rule per se in the statutes, although we're going to have some statutory discussion after this, but is a court rule that the courts are obligated to follow. It have been established in Florida. So, and there are a number of courts that word this rule somewhat differently, but they all come down to the same concepts. So I'm going to read this very long part of the slide and then go into detail into each section. So, board business judgment rule. Where a duly constituted community association board, upon reasonable investigation, in good faith, and with regard for the best interests of the community association and its members, exercises discretion within the scope of its authority under relevant statutes, covenants, and restrictions to select among means for discharging an obligation to maintain and repair a development's common areas a court should defer to the board's authority and presumed expertise. Now that's a lot, that's a long, that's a really a bad English sentence, but that's a long list of what we're going to go over as to what boards need to do in order to be making prudent decisions that will fall under this rule. So let's start with where a duly constituted community association board. What is a duly constituted community association board? Well, you would think that'd pretty much be a no-brainer, right? That's your board of directors. Well, on occasion, I have seen boards of directors where, particularly small ones, where, well, they didn't have an annual election. Everybody just kind of held over. Or maybe they appointed a director after someone left, but they didn't do it properly to notice meeting. They just asked Bob to come along to the next meeting. I've also seen situations where there was a spouse on the board and the spouse was not an owner of the property. And the document specifically said that every board director has to be an owner. That's a potential problem. I've also seen scenarios where you'll have officers who are not board directors. And you think, okay, why would anyone do that? Well, the reasoning seems to be that somebody in the community is willing to be the secretary, for instance, and take the minutes, but doesn't want to actually serve on the board and wasn't elected or appointed to the board, just takes minutes. Well, that should really be an assistant officer. That should not be an officer of the board. You do create a door for legal problems if you have someone who was not elected or appointed who's sitting there with an officer position on the board. So these are all considerations that are not common, but they are considerations and they're worth thinking about with that very first part of the rule, because if you do not have that duly constituted board, you might have a problem right out the gates, even though you did everything else correctly. So going back to this duly constituted board is now going to make a decision. Upon a reasonable investigation is the next part of the test. What is reasonable investigation? Well, beyond the obvious, along the lines of the board should be aware of its own property and trying to bring in assistance with the issues they're looking at, experts and professionals are really what we're talking about here. If we're talking about the type of repairs, the type of maintenance, the type of work that needs to be done, that's not just repainting the front door of the office, we're talking about most likely one where you do need experts and professionals to weigh in, to give you estimates for costs, maybe even to give legal opinions to ensure that you are, in fact, as an association, obligated to make these repairs and that there aren't certain limitations you have to follow. To have inspections of the property done, photographs, so that you have proper documentation for the decisions you're making. And I do find that not all of my boards for our clients understand that this information can also help protect you from liability as a board of directors. Getting reports, getting inspections, taking photographs, getting opinions, weighing in on the budget. These are all decisions that will show you made a very well-rounded decision and you took the advice of professionals. And that's not to say that you as a board have to take the advice of professionals. There could be options professionals say that if you take this option, this could happen, or you take this option, that could happen. You do have discretion, but when you follow the advice of professionals, you have some protection, and that you didn't just make a decision as a volunteer board, you made it with the assistance of professionals. And then as a practical matter, this information that you gather, your intel, can be used to help answer owner questions. Those of you who are out there who sit on the board of directors, I'm sure I don't need to tell you, whatever decision a board makes, there's the complainers, and then there's the people who also just genuinely have questions. And being in a good position to answer those questions and point to what experts told you, what information you got, will really help with your communications with your community, and maybe also help prevent any sort of dispute that might even come in front of a court. And then finally, as part of this process, for the reasonable investigation, you do want to make sure you're documenting all of this, that you are keeping legal opinions, you are keeping estimates, again, taking photographs, getting information from unit owners who may be involved or property owners who may be involved with the repairs and may have input or opinions. All of this documentation would help you if it is contested in a court. So the next part of it for the rule is you're acting in good faith. Good faith is almost not even worth discussion, is it? Well, except that it is. What is good faith? Well, it really means no favors for friends. Your friend Joe, who lives around the corner, doesn't get to do doesn't get a little better improvement than maybe Anne, who lives next door that you don't like as much. Can't do that. You probably already knew that, but you can't do it. It also means that you can't decide that that really problematic, noisy, dislikable person 3 units down, let's just say it's Nick. You can't decide that Nick doesn't get services just because nobody likes Nick. That's not how it works. In a condominium or homeowner association, everyone does have equal rights, and you can't decide just to single someone out, either for good or for bad. Good faith also does mean if you are potentially hiring a vendor or services that a board director has a potential conflict of interest with, that should be disclosed at a board meeting and follow the proper legal procedures for that. That's not really part of our seminar here, but that is part of acting in good faith. If it looks like that a board director's brother-in-law is going to be hired to put down the pavers, that needs to be disclosed and discussed and dealt with accordingly. So the next one is the best interest of the community. Well, wouldn't that be connected to good faith? And it really is. If you're acting in good faith, you're already halfway there. But best interest of the community also means recognizing your fiduciary duty as board directors to act in the interest of the community and not yourself. So you might think, for instance, that as part of the repair project, changing the color of a certain building to yellow is going to be great because you read somewhere that yellow buildings have a better resale value and you're looking at selling next year. Well, that's not a proper opinion to be bringing as a board member. That's a proper opinion to have as an owner. But when you're sitting in your capacity as on the board, you need to be making decisions regarding what is in the best interest of the community, not necessarily what you want or what might serve your interests. So the next part is, and this is not, by the way, in the rule, but this is something that is part of the rules as in the case law. It's just not stated in the Lambden rule. But the other act you need to make sure the board is taking is that you are taking your actions at a duly noticed board meeting. Now, what does that mean? That means that you have exercised whatever notice requirements are in your documents from the statutes for your board meeting, that you have a quorum at the board meeting, and that also, even though it's not part of the duly notice, that you're taking good minutes of the board meeting, that your minutes show that the manager or whoever puts up the notice is attesting they did that your minutes show that on the agenda was this decision to make this repair or maintenance obligation, and that the board did take a vote and it was either unanimous or the votes are laid out per board director. It also means these decisions can't be made at what's commonly called workshop meetings. I have to tell you, there are no unnoticed workshop meetings that are allowed under Florida law. When the board of directors meets in a quorum to discuss any association business, even if they're not going to vote, you have to have a noticed meeting where the owners can appear, with exceptions, by the way, for if you're meeting with counsel or there's some personnel issues. So there are some legal exceptions. But generally, if you're going to be making a decision about whether or not to replace the pavement with pavers in the community, you're not going to have those legal exceptions, and you're not going to be able to have a workshop meeting about it. And I have clients who say, well, if we open it to the members, they're going to come and take over the meeting and they're going to force their decisions and their opinions. No, you don't need to allow that either. The fact that owners come to a board meeting doesn't mean that they have the ability to take it over. It means that they have the right to come listen to the board's discussion. So you can put some limitations on when owners can make comments and how they can put their opinions in during the board meeting, but it is not like a membership meeting. It is a board meeting where the board discusses and makes the decisions. And your association counsel can help more with that. Finally, since we are getting through this very long list of what we need to do, is that you are acting within the scope of the board's authority under the statutes, covenants, and restrictions. What does that mean? Okay, well, let's start out if it's maintenance and repair. Is it the association's duty to do it? You want to start with that. You don't want to be repairing something that the association's not authorized to repair. And that's generally going to be a check with the governing documents. For instance, in a condominium, limited common elements may be maintained by the owner or the association or a combination of both. And that's going to be in your documents. So you want to get with your legal counsel and review that. Other items that may be unit owner rather than association could be windows, could be sliders. I frequently see a division of maintenance and repairs on sections of balconies or patios, such as if an owner installed screening or installed some hurricane protection, and flooring if they put down tile. And then another factor you have to consider with the maintenance and repair is what if the board thinks an improvement would make sense as part of the maintenance or repair. For instance, let's say the board wants to replace a wooden dock with the vinyl product that looks very similar to a wooden dock. Is that going to be something that requires an ownership vote? I mean, clearly the maintenance of the vinyl products is a lot better long-term than wood, potentially even safer and holds up. But is that something the board can decide, or are they going to have to ask the owners for that type of improvement? And some of the standard improvements are almost guaranteed to be asked for owner permission, such as changing colors or changing the substantive appearance of the common elements. Also, another decision that might not be maintenance or repair, but similar if you're going to make an improvement, such as put in a kayak rack or gazebo, you need to start with, does the board even have the authority to do that, or do they need an ownership vote? So with all of that word salad, so to speak, we now come to the end. If the board has followed these checklists and follow these protocols and the procedures and gotten the proper guidance needed from experts and legal, then the courts should defer to the board's authority and presumed expertise. That's the bottom line of this slide. What does that mean? It really means the courts don't want to second guess a board's decision. They figured out that decades ago when owners said, well, the board repaired this, but it could have been done better this way. Or I didn't like this. I think my proposal was better. The boards don't want to be in the guessing game of deciding which decision was the best decision. They are just going to support a board's decision that's reasonable and follows these protocols. So with that being said, I think, Alan, we're ready to turn to the statutory part of the conversation, unless you wanted to weigh in.
Well, I mean, you make a good point. The reason that this Landman rule was created was that especially going back to the 1980s, there were several appellate decisions where an owner had challenged a board's decision-making relative to major repair efforts. And I think the appellate courts got wary of hearing those type of challenges. And they created a rule that's much like a rule that applies to municipalities and counties and government officials who exercise the discretion within the scope of their authority, that for the most part, courts are not going to want to weigh in or be a referee on those type of administrative decisions. But the legislature's been very active in this area, and I'm going to go through a series of statutory provisions that the legislature over time has adopted, which affect fiduciary obligations of HOA and condo directors. So as a general framework, in both 718 and 720, as a protection to owners who feel aggrieved by board action, there is the authority under both these statutes for owners to bring claims against both the association and the directors for failing to comply with state statute and your documents. The owner who files a lawsuit has a right to not only collect damages, but ask a court for a mandatory injunction, either to stop a board action or to compel a board action. The legislature, in its wisdom, has determined that in those actions, prevailing parties can recover attorney's fees, and also added in both statutes that if an owner prevails, any assessment that they paid for the payment of the association's defense of the lawsuit is also returnable or reimbursable to them. So they did set up a fairly strong structure for potential owner lawsuits against associations and directors, and I'll get into the detail. This is from the Condominium Act 718-303. Again, sets forth in general what the requirements for an association and directors are, but compliance with the provisions of the statute, the declaration, the document, other documents, bylaws, and so forth. And this provides a statutory right for damages or injunctive relief. And as you see here, it includes an action against any director who willfully and knowingly fails to comply with these provisions. So that's the general parameter set up in 303 for potential action against 718-303 for potential action against board members. And here's the prevailing party attorney's fee language and the reimbursement that I talked about for assessments levied against that owner if they prevail for the defense of that suit. This is the section of the HOA Act 720-305, very similar. requires that the association comply with the chapter, the documents, rules, and provides that not only is there a potential for an action against the association, but again, under 720-305-1C, against any director who willfully and knowingly fails to comply with these provisions. You see again the prevailing party attorney's fee allowance. But the legislature has also weighed in on specific actions outside of those general parameters of complying with the documents and statute. And there's actually 3 statutory provisions, one in the Condo Act, one in the HOA Act, but there's also Chapter 617, which applies for not-for-profit corporations, which HOAs and condo associations qualify as 617 corporations. And these are the things that you can't do. They're pretty obvious. As a board member, no kickbacks and other freebies. Any violation, failing to perform their duties, failure is a knowing violation of criminal law. No self-dealing transactions, directly or indirectly. You can't act recklessly. And again, this goes to what Cindy indicated, equivalent to the Landon rule. You can't act in bad faith. You can't act with a malicious purpose. And you can't act in a manner exhibiting wanton and willful disregard of human rights, safety, or property. So the legislature has weighed in on all of those specific prohibitions. In Chapter 718.11, this is actually 1A, this is where in the Condominium Act it specifically states that the officers and directors of the association have a fiduciary relationship to the unit owners. Fiduciary relationship is the highest form of duty under Florida law. For instance, if you walk into a retail establishment, the owner certainly has an obligation to make the retail establishment safe, to protect you against attack by another patron, but they're there for profit. They have no fiduciary obligation to charge you a fair price for the merchandise or anything like that. Whereas a fiduciary duty is a higher obligation that officers and directors owe to the unit owners. Again, restrictions in the statute. You can't accept anything of service or kickbacks, not only to you, but to your immediate family, from anybody who is providing or proposing to provide goods or services to the association. If any officer solicits, accepts anything of value, there's a civil penalty as far as an additional criminal penalty. Why did the legislature include all this in the statute? Well, there were situations primarily in South Florida where there were certain associations, large associations, where actually millions of dollars were absconded with by both directors within the community, and there were some South Florida legislatures who heavily pushed for these type of restrictions to be incorporated actually in both statutes. Again, if there's a benefit derived directly or indirectly, or constitute recklessness or an act of omission as in bad faith with malicious purpose, wanton and willful disregard of human rights and safety, it's all included in the statutes. Under the HOA Act, which is 720, again, you have a provision that says that officers and directors have this fiduciary relationship to the members. So it's in both statutes. And again, very similar language under 720-3033, all these restrictions, soliciting or accepting goods or services for the benefit of a member or their immediate family. You know, I don't know if your cousin gets a benefit, whether that qualifies. So the legislature define what immediate family is. Now, what the HOA Act added was this is an obligation of that in 720 they placed upon the board. If the board finds that an officer or director has violated the subsection, the board shall immediately remove the officer or director from office. So this is a provision of that's in 720 that's not found in 718, which if you find that you have a director on your board who has done any of these malicious activities, you have an obligation to immediately remove them from office. There's no procedure, but I guess a board vote of the other board members to do so would qualify. And under section 4, director or officer charged by information or indictment with a felony theft or embezzlement offense involving the association funds or property is they're automatically removed from office. So there's a little bit more teeth in 720. So now we turn to 617, which is the not-for-profit act in Florida.
Alan,
yes.
I don't know if it's completely up to you. We've had a number of questions come in regarding the past couple of slides. Do you want to look at those real quick before we get too far past it, or do you want to save them till the end? I know Cindy.
Well, I'm actually going to ask Cindy to chime in on a couple of these. Cindy, there's a question: what would happen if the entire board quit, possibly leaving one member? Would that one member have a duty to keep everything moving forward? Would the quitting directors have any responsibility?
Okay, sorry, I have been trying to answer some of the questions in chat, but there are quite a few.
Yes.
Okay. If there is one man standing, so to speak, one remaining director, because everybody else quit, no matter whether that was 3 or 5 or how many directors you had, even that one remaining director has the authority to appoint new directors to the board. So I would not advise any one remaining director to try to make decisions or run the operations on their own. I would advise them to go out and find new volunteers to join the board. So, but did I answer that question in full? Is that what they were asking? I was looking for it.
Yeah, and then they also asked, would the quitting directors have any responsibility? Since they're volunteers, my guess is no, right?
Well, that's a bit of a loaded question. I mean, just because they decide to quit, no. I mean, it is not indentured servitude. Anyone who's serving on a board can decide that, you know, for whatever reason, they can't continue to do so. But if they quit to avoid certain circumstances where they're being questioned for bad dealing or bad faith or something, that could be a problem. But generally, yeah, a board director can quit just because that for whatever reason they decide they're done with being on the board.
Okay.
All right. There's a question from Joel about what's covered under an officers and directors liability policy. And the question is, are attorney's fees and costs recoverable? Generally, and I'm reading that is the association going to be defended by the insurance company, and those attorney's fees and costs, do they cover the association? And yes, that's generally what they're there for. In fact, in most cases, director liability, there's a finding by the court, usually on summary judgment, that doesn't rise to the level of an action. The insurance company is able to get the case dismissed, and then not only are your attorney's fees covered by the policy, but then you'll find that the insurance company and their lawyer will go after the owner who filed the lawsuit to try to get attorney's fees back from the owner, because the statute's reciprocal as far as attorney's fee obligation. Cindy, there's a question: is it legal or in good faith to increase HOA, I guess, assessments by 50% without presenting evidence for the increase and not allowing residents to have any involvement in the actions being taken. You want to try to tackle that one?
Sure. I'm getting asked a lot of questions about boards increasing assessments because I don't need to tell anybody, I'm sure on this webinar, everything in the state of Florida has gone up. Insurance, cost of living, for condos, particularly the new studies they have to do in the reserve requirements. So, but this one's an HOA question. So let me start by saying first, for condominium association, there is a provision in the statute where owners have a mechanism to petition the board to have a meeting regarding raising the budget over 15% from last year. There are some exceptions to that. One of the recent exceptions that the legislature added was insurance costs. So that 15% increase cannot include the insurance costs, which means that the math might not line up. That's a condominium provision that I have had HOA boards and just owners and people in town that I talk to say, well, why don't we get that? Well, unfortunately, you don't. That is strictly a Condominium Act provision. The Homeowner Association Act does not have a provision that allows owners a mechanism to have the board have a meeting because the budget went up a certain amount. Now, there may be something in that HOA's documents. I can't speak to that. That would be specific. But there is not something where there's that mechanism for the owners to question. But this specific question asks really, is it legal or in good faith? Well, the devil would lie in the details, because if the board, even though they didn't communicate well to the owners, but ultimately could show that their increases were because of increased insurance, because of increased reserves, because they weren't being funded, or for other business legitimate reasons under this same Lambda test we were discussing, then that decision is going to be in good faith. It's just, this sounds like this question's coming out of one of the problems I see almost every day with community associations is good communication is key. And if a board is increasing their budget by 50% and not really doing a good job of telling the owners why, and I'm not saying this board is or isn't doing that, I don't even know what this community association is, but that is very much key. And it's not part of that test we've discussed or the business judgment rule, but it's really a way to try to alleviate some of the concerns and problems that can appear in a community when a board does not communicate in a way where owners understand the decisions it's making.
All right, there's a question from Miriam. Then, after this question, we'll get back to the rest of the presentation. But there's a lot of very good questions that are coming in. If a board quits all members, please explain the procedure and possible fees to the owners if we have to turn the association to the state. So both 718 and 720 have a receivership provision. So if there's not an acting board of directors of an association, any owner can go to circuit court, ask for a receiver to be appointed by the court to actually take over association operation. And then that receiver will actually be operating the association as acting, on behalf of the board. Now, one of the things the receiver can do is they can call for new elections, get a board, a proper board in place, and then go back to the court and have their receivership dissolve. And I think most receivers, if they're appointed, will move towards that. But until an acting board is in place, it's an expensive process because you're actually going to pay the receiver. They're entitled to be paid a reasonable fee for their services. A lot of times it's somebody who comes from the management world who's appointed as a receiver. Their fees are set by the court, and they actually during that process will operate the association. Let me see. All right, there's a question from Charles. Are former condo association board members whose terms have expired still legally responsible for actions during their term of office? I'll say yes, just because if you've committed actions that are a breach of your fiduciary duty, or if you stole money from the association or done other nefarious acts while you're in office, the mere fact that you resigned does not alleviate your potential liability. So it will follow you. And at this juncture, let's get back to the slides. So I started talking about chapter 617. This applies to not-for-profits. Again, very similar language. There's no liability, which is the way the 617-08341 starts out. No personal liability for any statement, vote, decision, or failure to take any action regarding organizational management or policy by an officer or director. And then there's that magic word unless. So this is the exceptions. Again, breached or failed to perform his or her duties as an officer, and under B, there's a violation of criminal law unless the belief his or her director had reasonable cause to believe his or her conduct was lawful and no reasonable cause to conduct was unlawful. Under 2, another exception to having the shield of the statute. Again, if you derived an improper personal benefit directly or indirectly, you were reckless, committed an act in bad faith with a malicious purpose. Again, the wanton and willful disregard of human rights, safety, and so forth under the Not-for-Profit Act. All right, we're gonna change course a little bit because in the face of what the legislature created and the court system has created over the last 40 or 50 years, the legislature in 2022 acted to add an additional fiduciary duty requirement for, or 2 of them actually, for condo associations. And what you'll find as Cindy goes through this is different in tone than the way both the HOA Act and the Condo Act were written, and even the Landman Rule. So this is a bit of an aberration. Cindy, why don't you go through this as to milestone inspections and reserve requirements for condos and this addition of this fiduciary obligation?
Yeah, again, this is only for condominiums. And this change was made as part of the milestone and inspections, the other inspections that came from the Surfside tragedy. As you can see in the statute here posted on the slide, and the part regarding the mandatory milestone inspections, the Condominium Act provides that if the officers or directors of an association willfully and knowingly fail to have a milestone inspection performed, such failure is a breach of the officers and directors' fiduciary relationship to the unit owners under 718-111. This really raised some eyebrows in the community association legal world when it came out, because previously these examples we've been discussing were the ones that were the standards for reviewing fiduciary duty. This is a specific statutory provision saying that you will breach it if you do not do this. And there was a lot of discussion at the time that this was implemented, is even though this might have made practical sense from the legislative standpoint, remembering that board directors are volunteers and not all of them have management companies, and not all of them have maybe even lived in Florida for the last 6 months and have noticed some of the changes and provisions. Was this really a good idea to put this type of burden on board directors in terms of making sure they do this very important milestone inspection test? So there's an academic debate there whether it was a good idea, but the fact is it is in the statute. So there is a risk here for board directors who are not aware that that's an issue. And again, on this next slide, the structural integrity reserve study as well, that if an association fails to complete a structural integrity reserve study pursuant to this paragraph, such failure is a breach of the officer and director's fiduciary relationship to the unit owners under 718-111. So again, academically, it can be discussed whether these provisions really make good sense, considering that board directors are volunteers and the standards that had been established since the 80s. These really fall outside those examples, but they are here, and all board directors do need to be aware of them. Alan, did you want to add anything to that?
No, I think you covered that well. what I want to emphasize with this next slide, and it's because we've been talking this entire session about the liability and responsibility of individual boards of directors. But keep in mind that the association as a corporation also has potential liability. So if the board determines, let's say, to undertake a particular repair, and the repair is undertaken at the association's direction, ends up the repair fails, there's damage to units or individual owners as a result, there may not be liability on behalf of the board of directors for the repair that wasn't undertaken appropriately, but the association as an entity under and probably protected by its liability policy or its property insurance would still have potential liability. So you see lawsuits being filed every day against associations for negligence. They usually don't include the individual directors as defendants in those cases, but don't confuse that the restrictions on board liability as necessarily restricting potential association liability, which is broader. It's just a negligence standard. The association has, as a corporation, has the duty to act reasonably in undertaking its activities. And if an owner can prove in court that a particular repair, for instance, wasn't done reasonably, or that there was negligence in the undertaking of it, it still has the potential of creating association liability outside of director responsibility. Another issue that often comes up is, and I take the example of really what happened in Southwest Florida. There are several condominium and homeowner associations who are still waiting for their insurance company to respond to insurance claims. None of the repair and maintenance obligations for associations are suspended while either you're waiting for insurance companies to respond, or if you have a defect case against the developer, your obligation to maintain and repair is not suspended during that process. And why don't we, at this point, we have 15 minutes, we're going to go into the question and answer session. Back to it. Cindy, have you seen any questions that you particularly want to respond to?
I've been trying to respond to questions as best I can. There's a lot of detailed questions, which is great because it means people are thinking about what we're saying and they're asking good questions. To answer your question, I was just actually looking for a new one. Let's see. Alan is one.
Here's a good one for you, Cindy.
Okay.
And we can answer this together from Joel. Can an association countersue a plaintiff owner for abusive process, bad faith, where the principal motivation is refusal to pay an assessment, assume board communications were not ideal, but decisions were prudent in good faith, and so forth? Cindy, do we have any experience with dealing with owners who are abusing their position as owners and coming after a board of directors with lawsuits and complaints and so forth? And what's your recommendation for dealing with it? And is there a potential for cause of action back against the owner?
Well, usually you don't see it rise to litigation, but I have certainly seen, and it goes back actually to your insurance claims position, Alan. We've seen situations where we had client condominium associations damaged quite badly by the hurricane further south, and owners have said they weren't going to pay assessments because they can't live in their unit. And they can't live in their unit because it was badly damaged by the hurricane, not necessarily because the association isn't trying to take the actions to do what they need to maintain and repair it. The condominium law and HOA law is very clear. You cannot refuse to pay assessments under protest, so to speak. When you buy into a homeowner association or condominium association, you're buying into a corporate entity and sharing your interest in property with other owners. So you don't get to make a claim along the lines of, I don't get what I want, so I'm not paying. And the law is very clear about that, because can you imagine if everyone could do that? No one would pay their assessments. To be like, well, I don't like how you cut his bushes. I want mine cut just as well as his. And until then, I'm not paying my assessment. And yes, I'm being facetious. But the point being, no, you cannot as an owner not pay assessments under protest to a board decision. Now, you could, as an owner, not pay assessments if, for instance, they were not doing a proper accounting and not showing you made payments. If there was some sort of in-house financial dispute, that's not what I'm talking about. But I'm talking about if an owner does not like how the board made decisions regarding improvements or repairs or maintenance, they don't have the legal authority to just not pay assessments under protest. So I think the other part of that, though, was a countersuing. So I'm not quite sure, Alan. I'm not sure what scenario where there would be a countersuit. I guess maybe the presumption here is that the association's already pursuing the owner for assessment collections. I don't really know what that part of the question's looking for.
Well, I'm reading it as, now with websites and so forth, an owner can send abusive things to the board and to the ownership about individual board of directors. We always get into discussion of potential libel and slander actions. Really, how do you stop an owner who, because the association is seeking relief from them, either it's from covenant enforcement or assessment, or they're just complaining. How do you stop, constant abuse of directors, either online or discussions within the community?
Yeah, no, that's a hard thing to do, because I mean, this is a country where people can post their opinions online, where people can dispute what they think is the right thing to do. That being said, I can say that I've had associations where an owner was so abusive and threatening and off the rails, so to speak, that the board has advised them, we will not respond to your emails. That if you have issues, you can bring them to the meeting and you have your 3 minutes just like everyone else. You can put some limitations on that. If there's a Facebook page the community is unofficially running and someone is posting slanderous, defamatory, or other really egregious comments, and I don't mean just general complaints, I mean really, unprofessional, nasty stuff, you can, the board can send a notification to whoever's controlling that Facebook page that they need to make clear that that's not acceptable behavior, that they need to be taking actions to step in. But that being said, I will say that a lawsuit is pretty much the last thing I would recommend. It can get very expensive, and the differentiation between somebody's opinion and the fact they're not really very nice is very different than being able to establish that someone defamed the board's character in such a way that they suffered financial damages. So those are, we could almost do a seminar just on this discussion. So I'll wrap that up there so we can get to other questions.
All right, there's a question from I believe it was Karen. When a builder board of directors changes over to resident board of directors, are there any specific state statutes to help or guidance with transition? Actually, in both 718 and 720, there's a specific statutory section regarding transition requirements. There's also provisions in both statutes as far as what kind of documentation needs to be turned over. So reference both the 718 and 720. I don't know whether you were, Karen, you were condo or an HOA, but both statutes have pretty specific requirements and guidance as far as transition from developer control. Cindy, there's a question from Janet. How do you resolve the conflict of board members with diametrically opposed views on what is the best interest of the association, such as the case of an expensive repair versus the ability of owners to afford the expense? Want to take that one on?
Yeah, well, you are gonna have scenarios where board of directors aren't going to agree, and that's not really something we've talked about as part of this presentation. And you could have, and this is something why I advise my community associations not to have an even number of board directors, because you could end up with a stalemate where a decision doesn't get made, and that's not in the best interest of the community. So that sounds like there is some conflict here with the boards not agreeing. as to what the best interest of the association is, and that can be a disagreement of opinions. But the second line here, the case of an expensive repair versus the ability of the owners to afford the expense. That second part of the question is not the assessment. What the association needs is what it needs, whether it's expensive or not. Taking into consideration whether owners can pay for that is going to sound rather harsh for me to say this, but the fact is that's not what the board's duty is. The board's duty is to maintain and repair as needed the association property and whatever is needed to run that corporation, not to weigh into whether owners can afford it or not. Because honestly, if they can't afford it, it's like anything in life. It's maybe time for them to make some different personal decisions and move on. And again, that sounds harsh, and particularly when you're considering your neighbors, if you're a board director, but that is the corporate duty. It is not to assess whether the owners are going to be comfortable with these expenses, it's to assess what the corporation needs.
All right, Cindy, there's a question about committees from Molly. Our president of the board is really into committees. These committees are made up of owners that have expertise. The committee recommendations are then mostly adopted by the board. Do these committees bear any responsibility, or the buck stops always with the board? And you could probably also talk about what the notice requirements are for committees. I know it's different in 720 than 718.
Yeah, I was going to say this, that we could spend 15-20 minutes on this one alone. The problem with committees can be that they make decisions without posting their meetings or not taking minutes. So you don't have good documentation. And even when the documents don't necessarily require the committees to post their meetings and give notice or take minutes, again, you can run into a problem because you are asking other volunteers in the community to weigh into decisions the board is going to make. So, do these committees bear any responsibility? Well, it depends on what they're being asked to do. And they could be being asked to make decisions that aren't even covered by directors and officers' liability coverage. So that's another concern to look into. And the question, does the buck always stop with the board? Well, the board is the entity that runs the corporation, that is the association, whether it's a condominium or a homeowner association. But there are certain sets of documents, for instance, that have architectural review that is vested in the Architectural Review Committee, and it literally stops there. The Architectural Review Committee's decision is final. There are some other scenarios where that occurs. So no, the buck does not always stop with the board. But generally, if you're not going to have that happen, you've got to make sure that those the proper notices and the minutes are being taken of those meetings, because if a final decision, whether it's condo or HOA, lies with a committee other than the board, they have the same obligation as the board does to properly notice and take minutes. It's not just advisable at that point, it's required.
But the final determination is going to be made by the board of directors, and the board of directors, even though committees are established on an advisory basis, the board of directors makes the final call.
If they're advisory committees, I'll give an example. Some boards like to have committees go out and research and get them vendor quotes, for instance, for landscaping, or for building painting. And that's an advisory committee that gets quotes and reports back to the board. That can be a very useful tool for the board. But yeah, the board will make the final decision for advisory committees, most certainly. Yeah.
Balfour, you asked a question about solar rights, and I looked at your question. It's going to be very dependent on the particular makeup of your community. So we're not gonna tackle that one here.
There was a question, Alan, about homestead rights, whether if homestead protects you from paying assessments.
Right.
I want to hit that one real quick.
There you go.
No, it does not. It just like if you have a first mortgage on your property, whether or not your homestead, if you have a direct tie to the property and the debt, that is not a protection from the debtor taking your property from you. And for both condominium and homeowner associations, lien rights that they have for not paying assessments will take your property regardless of whether it's homestead or not.
There's an interesting question from Christopher. We have a substantial minority of owners pressuring the board to make financial decisions that subtly favor sellers over stayers. If that's ever allowable for a board to do within the fiduciary duty, we face a different and more difficult reality than if it's never allowable. I've always taken the position that the board of directors has an obligation to serve the interest of the property over the long term. So it's not only what's good today for the association, but in 5 years, 10 years, and 20 years. And if a board of directors is making decisions that are, for instance, protecting property values in the short term, some boards will say, well, we need to keep the assessments down and avoid some major projects because there's some people who are trying to sell the units, and we've had situations where actually directors have their units for sale. If those decisions are being made to benefit really short-term interests over the long-term interests of the association, it arguably would be a violation or a breach of a fiduciary duty to favor people selling over people who are going to be staying for the long term. There's a question about Chapter 719. Basically, the provisions of 719 as it relates to fiduciary duty are very similar to what we've discussed. Cindy, there's a question, I think you tried to answer this by typing, but the common element condominium associations, saunas were closed. Does the board have an obligation to get them reopened?
Yeah, and I was typing an answer. It says common element saunas, but common element could be HOA or condominium, not entirely clear to me. What I was recommending, though, as a step, regardless of whether it was condo or HOA, is looking at the bylaws for there's going to likely be a provision where a certain percentage of owners by petition can demand that the board call a membership meeting on a particular issue. So that would be my recommended first step, not knowing any more details than that the membership start by circulating a petition and presenting it to the board with whatever percentage they need of signatures, demanding that the board hold a membership meeting on this issue so that the board can answer questions the members have.
All right, there's a question from Ralph. In the event that there are differing opinions among the board on how to proceed, for instance, on a large repair, wouldn't a good approach be to focus the board decisions on outside expert opinions, engineers, contractors, etc.? That's accurate, and I think one of the ways to avoid board conflict on major repair decisions is to seek that expert advice. And then for the board to say, look, let's just leave it to the engineer to make their recommendation on what's really necessary, and let to the degree that we can proceed as the engineer recommended. I think that's a good way for disputes within the board as far as repair obligations to be determined. Cindy, I think you've already answered this question about committees. A committee that's reviewing bids or issues for informational purposes but not making a decision, does that type of meeting need to be noticed?
Likely not, but there may be a provision in the documents that requires more than the statute. So I have to caveat with that. You do have to confirm that even though the statute might not require notice, your documents might.
There's a couple in here, Alan and Cindy, from Jason, asking about like the milestone inspection, for example. Is it if you have a management company, is it the management company's responsibility to present this type of information to the board, or does the final responsibility really truly fall on the board in those type of situations?
Well, let me answer that question. Your management company is not a lawyer. If you're asking for guidance on the applicability of the provisions of 718 or 720, and you have doubts, you're best off going to your general counsel for guidance on what the legislature provides. Actually, management companies can't give legal advice, and interpreting the statute and specific requirements that an individual association has probably could get a management company in trouble. I would say at a minimum, a management company should let you know that there is legislation that impacts the association and make the board generally familiar with what those requirements are. But I think most management companies at that point would say, look, we know that this is in the statute, but what your particular requirements, the time periods for action, what needs to be included within these studies, that's really for general counsel to respond and not your management company. But certainly highlighting to you what the general statutory requirements are is probably a good practice by a management company. So I'll leave it at that. Somebody wrote at some point that, of course, that question was not directed to Castle Group, that does an excellent job on all occasions as far as advising their associations.
Thank you.
All right, there's a question from James. Do the statutes allow for or encourage alternative dispute resolution prior to litigation? Again, under both 720 and 718, there's a specific group of disputes that actually require a mediation arbitration process before you could go to court. So one of the things to do if you have a dispute is contact your counsel to determine if it's a type of dispute that does require mandatory mediation or arbitration before the division. So there are particular disputes where that is actually required. If you get into court, most courts will require that once you're in court that an action be mandated or mediation be mandated. All right, there's a question from Tom. What action does a board have when an owner makes their own repairs or improvements where permits were not acquired and have impacted common element? Cindy, why don't you talk about and answer that question first, is what the board should have as far as covenant and rule to make very clear what's allowed or not allowed relative to owner improvements.
Yeah, the associations, particularly ones that are, for instance, a condominium building where they're a shared interest, should have board policies and rules that are followed to avoid those scenarios. Because many times owners will proceed and then later say, well, nobody told me, I didn't know. Regardless of whether somebody told them or they didn't know, when you have a good policy, it's harder for an owner to take that position. So that right there can be a workaround to avoid those scenarios by making very clear that protocols have to be followed and permits and sometimes board approval, depending on the circumstances. Alan, I was looking for that question because I was answering another one. What was the second part of that? Was it
what action could be taken? And basically, if an owner's either violating the statute or violating the documents and refuses to bring the condition of the property back to its original condition, you would have a right to, association would have a right to go into court to get a mandatory injunction to require that owner take action to put that the common element back in its original condition, or the association could take the action and then have an action against the owner for the cost of reestablishing conditions back to their original form. Shauna, we're happy to go on indefinitely, but it's your show here. There's a question from Cheryl. Can the board president choose to not fully insure the condo association funds and property value if they can? Is there an acceptable level? For example, 10% of the value. Want to tack that one, Cindy?
Sorry, I was answering another question. So which
Well,
this
it's
one?
really a question, and it sounds like in a condo, whether there's an obligation to fully insure up to the insurable value, or whether the association can, when she says 10%, maybe she means 90%, but can there be a choice by the board president not to fully insure in a condo?
Well, their statute does require the board to undertake best efforts to ensure all of the condominium property. So any decision not to insure the condominium property in full is going to be a decision that has a statutory issue and really should be discussed specifically with counsel, because what has occurred, and I'm sure this comes as a shock to no one on this webinar, is that insurance premiums have skyrocketed in such amount that it's almost cost prohibitive for certain associations to get insurance. But the Condominium Act did not anticipate this, and it does not really give wiggle room there. So that's really one I can't answer and avoid, but I would say that there is a statutory requirement that needs to be followed. And to the extent the board is looking at not following it for cost reasons due to the insurance market, that's really something they're going to discuss specifically with their counsel.
Cindy, there's a question. When should the board release a milestone report to outside realtors and potential buyers?
That's a good question.
Well, I can answer it.
Please do.
All right. The materials that are association documents, association records, these are available to individual unit owners.
Mm-hmm.
It's generally a mistake to release association documents to outside realtors and potential buyers. Now, an owner can request them and get copies of them. If they want to provide them to a potential buyer, that's their option. But I think it generally is not a good practice for associations to be providing association records to outsiders. It's also a burden on both the time of management and individual directors in order to be providing that information. There's a standard question and answer sheet that's available. The documents for an association are public record that any realtor or potential buyer can review. But if they want to go to their seller and they want particular information, generally the best route is to tell the seller, I'm interested in buying this unit, or can you get me this information? They can then go to the association, get the information they need. If they want to pass it on to the realtor or the potential buyer, that's fine, but generally not a great practice for the association or management to be providing that information directly to outsiders.
So we have what, about 32 questions. I don't know if we'll get through them all. If you guys have a few minutes you want to stay on, we could kind of do a rapid fire. I can start at the top and kind of read them off to you guys. And if you have a quick answer, great. If you don't want to answer, that's fine. We can reach out on the side. Do you guys want to try to do something like that? Or do you have the time for that?
We have the time.
Yeah, we got the time. Yeah.
Well, I guess let's start at the top here. Somebody asked, do conflict and fiduciary provisions also apply to property managers hired by the board?
Well,
yes, everything we said in the seminar about director liability, there's equivalent statutory requirements, both by statute and rule governing management companies, and they have very similar obligations. So now the management company serves at the behest of the board.
mm-hmm.
So their relationship, different than a board of directors, is not directly to individual unit owners. They are responsible to respond to the board. So the scope of their relationship is more tied to the corporate management of the association versus individual owners. But certainly they can't abuse their position to the detriment of any particular owner of the community either. So it's very similar.
Okay. Next one, quick. Brian asked, I guess their HOA rules require abiding by applicable traffic laws, and there's a $100 fine for violation. So long and short, does the director breach a fiduciary duty if that director has the opinion that this is police business, not HOA? And therefore will vote to never to vote to enforce the rule, impose the fine.
Well, there is a line between a board director having an opinion along the line of thinking something just isn't right, or they don't think it lines up, and breaching a fiduciary duty. Breaching a fiduciary duty is a high standard. It does involve making what we considered grossly negligent or knowingly even bordering on criminal decisions, such as, taking association money and going up to the Hard Rock Cafe in Tampa, which would also have criminal ramifications. So to the extent this board member might be particularly stubborn, and maybe even the association's attorneys told them this is a proper use of the association's authority, this board member may be of the opinion that they just don't support this particular provision, which I don't think would, again, without more facts, it doesn't look like a breach of fiduciary duty, but does look to me like this person really should be and could be fairly asked, do you really want to serve on a board where you feel like you're letting your personal opinions get in the way of what the rules and regulations state?
I think one of the problems with the question, one, it would depend on whether these roadways are owned by the community or whether they're public roadways. If they're public roadways, you might need to leave it to the authorities to undertake any sanction. But one of the things I see problematic is, what's the standard of proof? I mean, do you have directors who are standing on the roadway watching for people running stop signs? And is there appropriate committee structure in order to see the proof and undertake these fines? So that's
my answer presumed that this issue that the board director had been told, perhaps by legal counsel, that it was proper for the HOA to do this. But Alan raises a very good point. It may be that this owner is raising questions that have not been answered by legal counsel.
Okay, so next one, I know this is a whole topic on its own. I don't know if you have a quick answer, but will board members be required to file financial information under the new legislation requiring filing if they have ownership interest?
I'm not familiar enough with new legislation that's being proposed to know what that's referring to. I know there's currently there's buzz in the press about the governmental, local government folks who have had to produce financial information, and some of them have chosen not to and have resigned from various cities and towns boards, but that's not a condominium or HOA issue.
And let's see. So board president, along with the entire board, hires a management company, and then before the president's term has expired, they resign from the board and is hired by the very same management company. Is this self-dealing by this board president?
Without more facts, not necessarily. There's nothing wrong with somebody particularly, deciding they want to go take a particular job and they leave the board to do so. There's no inference, for instance, that person made that decision going back months ago, knowing they were going to take that job. So based on those facts, you'd need more.
Yeah, did they do anything nefarious to benefit their potential employer, while they served on the board of directors, would be the question.
Yeah, okay. And let's see. Former condo association board member whose terms have expired, still legally responsible. Oh, are former condo association board members whose terms have expired still legally responsible for actions during their term of office?
Yeah, we did. We answered that already.
Okay, that one's been answered. Okay, perfect. I thought I was trying to keep up with the ones that have been answered, but I missed some.
There's a lot of questions.
Yeah, if a director votes on no on a budget that the board passed, but was later to be found to have actions in it that was found by the court to be illegal, can those directors who voted against it be immune from a liability?
Potentially. That's a loaded question. A lot of presumptions in that. But I mean, more generally, a board director voting specifically no for something and stating their reasons for doing so may protect them from liability generally that other board members won't get protection from because they did agree. I can say that.
If association pays water and owner is in arrears, can water be shut off by the board?
That's really going to be document driven, but odds are no.
Yeah.
Maybe if it's a commercial entity, maybe, but as far as residential goes, water is a requirement for health and safety.
Alan, you already talked about the solar rights one. Our COA saunas were closed without ownership voting. How do we demand restoration?
I answered that one saying there should be a
Okay.
provision in the bylaws for
Okay,
demanding a membership meeting.
Does a grace period to pay assessment stop any late fee for the published assessment due date?
Well, that's another loaded question because what is that grace period? Is that something, for instance, I have associations who change management companies, and as part of that transition, the board will impose a grace period so that people have time to change their payment methods and transition. That's a very different grace period than one that maybe someone thinks is in the bylaws and they're arguing over what that grace period is. Not all bylaws are very clear on when your assessment is specifically late. Mm-hmm. So I really can't answer that without more detail, but just to offer those general thoughts.
Perfect. If the board takes out a loan, can it be tacked onto your dues or does it have to be set up separately?
Well, that's going to depend on what the loan is. Honestly, because some boards have the authority to take out loans that under their documents are not falling under an assessment. So that's really going to be a document driven question. But generally, if the association is taking out a loan to conduct the topic of this particular seminar to perform maintenance and repairs, it's going to be part of the assessments.
Do the statutes allow for or encourage alternative dispute resolution?
We covered that one. We covered that one too.
Okay.
Yeah.
Let's see. Our common element COA saw. Oh, we already did that. I think a couple people, when we didn't answer, retyped some. Along with my four. Okay. If board members choose to select its own management company different than the master association, okay, so we're talking about a sub, and all building associations, because the board members of the association use is related company as its rental agent profiting. I'm not sure I'm following this one.
Yeah, Ted, that's far too much detail and entry to try to answer in a public session like this.
I think this is too broad of a question as well.
Yeah.
What is the obligation exposure of the management company?
Yeah, that is a very broad question.
Yeah, I think that may have been something tacked on as a different question. If a board member chooses to select it to, oh, wait, hold on. It moved on me. Is there some law, regulation, or guidance governing parking space assignments, particularly when most assignments are on floors with access to elevators, while few parking assignments do not have access to elevators?
No, there really is not. The only guidance in the statute is going to be whether or not your parking spaces are common elements or limited common elements, and you'll need to follow that. But other than that, that is a document-driven question.
Okay. Oh, that was something else. Sorry. Let's see. If a condo association board neglects to consult legal counsel because they are afraid of fees, and therefore thereafter, for example, enter into a contract weighted in favor of the vendor versus balancing the interests of the association, is that a possible violation of the business judgment rule? So in other words, they didn't have the attorney look over the contract, and the contract isn't in the best interest of the association.
Well, Charles, let me answer that question this way. It certainly is better, especially on a major contract, for an association to consult legal counsel. If they don't, and the contract ends up to be not in favor of the association, as long as that individual director did not get any pecuniary benefit from that particular contractor, it's very doubtful that that there would be, it would make it actionable. I wouldn't call that a breach of fiduciary duty, more, you know, maybe not the best practice, but I doubt that if that board member or the board of directors was sued for that it would get too far in the court system before there probably a summary judgment entered against the complaining owner.
Jason, I think this was back to Jason's other question about milestone inspections and whether it's the responsibility of the management company or the board. And he said, in this case, should the general counsel be giving us annual legal updates with regard to such matter? So yeah, generally there's always a legal update every year, and most attorneys, you know, I know you guys do a lot of, you know, most firms provide some type of legal update, whether it's via email or via webinar, but
and there's lots of educational opportunities like the webinars that Castle Group is doing regularly where these issues are covered.
Yeah. Do Florida laws and statutes and local government laws supersede co-op docs and bylaws?
That's a vague question, and I don't practice co-op law, so.
I believe, let's see, where
It would depend on the statute and the governmental regulation.
Where in the 720 statute do we find the annual budget allowed increase before residents need to vote on a suggested increase?
Okay,
isn't that generally in the documents or no?
Well, yeah, it is in the documents. I must not have been very clear earlier when I discussed that there is no provision in the Homeowner Association Act which triggers an opportunity for owners to contest a raise in the budget. There is one in the Condominium Act, but not in the HOA Act. That being said, it could be in the HOA documents.
Yeah. Is there any other boards getting requests to approve fractional ownership?
I have not seen that.
Okay. Didn't the new laws mandate release of milestone inspection and SEERs to buyers under contract? You touched on this, didn't you?
Yeah, Cindy, did I give the right answer to that question?
Yeah, this is, I think this is more specific. You were saying generally that, you know, they shouldn't hand these out just to realtors, but if there is a buyer under contract, that is a different set of facts. So you answered it more broadly, that's more specific. And yeah, there is a provision for that.
Okay.
I'm confused about the milestone inspection, when to provide okay, we just talked about that.
Right.
Does Corporate Transparency Act apply to condos and co-op?
Well, again, I don't represent co-ops, but anytime there is a meeting of the board of directors of a condominium at which a quorum is obtained to discuss the business, they have to have an open meeting. So the example I give is if you have a quorum of the board watching the Super Bowl, you don't have to notice that. That's not association business. They're interacting socially. But if the quorum of the board is getting together to discuss the association business, that has to be an open meeting. And again, it goes back to why I say that you can't get around that by having a workshop meeting. It doesn't matter whether the board's going to just talk about something or whether they're actually going to take an action item. If a quorum is present, discuss the association business, they have to post notice of the meeting so that the owners have an opportunity to attend.
Oh, this is one I get a question, not specifically this painting project, but this is one I get asked a lot about. Should a board allow unit owners to volunteer to do a large painting project to save money after they received 3 bids from professional painters? If so, should the volunteers follow the same specifications as required in the RFP? Okay, that's not the question I get, but I do get a question while we're on this topic about residents volunteering to do projects and the liability that lies there.
Well, I could take this one on. Bad idea.
Yeah.
Bad idea for several reasons. One, if even as a volunteer, if you take on a project and somebody's damaged as a result of your activities, you could be sued individually for that, no matter what your status was with the association or the volunteer nature of it. You're not covered under any kind of workers' comp act. So, you know, if the maintenance employee of the association is probably carrying workers' comp protection, but if you're an individual director doing the same thing and you get injured, you don't necessarily have workers' comp protection. So I could probably list several reasons why. We have on our board of directors people who are, lawyers, accountants. There's general contractors. It's very tempting for them to sometimes perform work themselves or administer a project. We've had, engineers from Indiana who are on a board of directors, and they're making decisions on repair projects in Florida. And we've told individuals in that situation that, number one, your Indiana professional liability policy as a licensed Indiana engineer does not protect you against the unlicensed practice of engineering in Florida, and dissuade them from, they can certainly participate with a Florida engineer in formulating determinations, but always should be undertaken by somebody licensed in Florida. So generally a bad idea for several reasons.
And I would also just add that paint's really expensive. And people might think that they can paint the exterior of a building and do it just as well as professionals. I'm just going to tell you no. Go to go to any of the vendor seminars about painting and learn how actually complex it is to properly paint the outside of a building in Florida.
And usually with, using a vendor, there's some type of warranty involved and all of that.
Oh yeah, Sherwin-Williams is not going to warranty their paint if you let Bob around the corner put it up.
Exactly. Yeah. Upper unit is leaking. Owner will not fix it. Can the water be shut off by the board?
Odds are no. Again, water is required for health and safety reasons in a unit. That sounds like kind of a self-help that the board is looking for. I hate to say it, but it's best to go to council and start a process where that demand is made on that owner legally.
Well, Cindy, I don't know if I'm reading that question the same way you are. If there's an active leak and that's damaging other units or the common element, and on an emergency basis, cutting that water off will stop the damage from occurring. Certainly on a short-term basis, that type of self-help should be considered. In fact, under the Condominium Act, we've had situations where, owners out of the country and their hot water heater fails and there's active leaking occurring within the unit. The 718 would authorize actually the association, after attempting to contact that owner, entering that unit and taking action to stop that leak. So
I agree. The emergency analysis is entirely different.
Yeah,
you're right. I did presume a scenario like I have seen associations have where an upstairs unit owner has some sort of ongoing leak that's not an emergency, but is damaging the ceiling noticeably in the unit below.
Right.
And the board is looking for guidance on that. So yeah, you're absolutely right. Two different answers for the scenarios involved.
All right. I think you guys already kind of touched on this with another question, but worst case scenario, everybody quits the board. Does the state take over?
Again, that would allow any owner to go to circuit court to get a receiver appointed to then be operating the association until a duly elected board is in place.
But again, this concept that the state takes over is not a thing. You have to, a court action has to be instigated. The Department of Professional Regulation is not just going to step in and take over your condo HOA. That's a misconception.
And last but not least, so Betty's saying that their bylaws allow closed workshops, and are we allowed to do it, or do we have to open it for unit owners as well?
This can be the disadvantage of having older documents, is they're not necessarily up to date with current statutory laws, and whether or not a current provision is overridden by the statute, a discussion to have with council. But for the open meetings, that is one that is required by statute, end of story. Regardless of what your bylaws would say about that as a general rule.
Well, Alan and Cindy, we've cleared the Q&A. So thank you all. You stayed on an extra 30 minutes with us. So thank you. And we still had 162 people who stayed on to listen. So,
oh, wow.
So yeah, So thank you guys so much. This was very informative, fantastic, obviously very engaging. We had a lot of questions, a lot of good questions. And we really, really appreciate you guys taking the time to join us today. And we appreciate everybody who joined us, as a board member or committee member, resident manager, whoever you might be. We appreciate it. And we will, like we said, we'll send emails out, Laura and I, before end of week that will have Cindy and Alan's information there. So you guys can reach out to their firm if you would like to, engage them further. And we will include, as long as you guys are okay with it, we'll include a link to the recording of this. Are you guys okay with that, Alan and Cindy?
Yes, sure.
Okay, perfect. So we'll include that. And thank you. I hope everybody enjoys the rest of their week. And Cindy, Alan, we look forward to doing some more stuff with you in the future, and hope you guys enjoy as well.
All right. Thank you for the opportunity.
you.
Appreciate it.
Thanks. Take care, everyone. Bye-bye.